Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about the right to a preliminary inquiry. Cases that should have gone to the Supreme Court of Canada, but didn't. Jason Windebank was charged with a series of offenses that wouldn't necessarily attract the right to have a preliminary inquiry, but he was given notice by Crown that they would be seeking to make a dangerous offender application if he was convicted of those offenses. As a result, he faced potential lengthy period of imprisonment that, if it had been the sentence for the offenses for which he was charged, would have entitled him to a preliminary inquiry. He challenged the refusal to grant a preliminary inquiry to him on the basis of the fact that because he was still facing that type of jail time, notwithstanding the fact that it's not the penalty for the offenses for which he was charged, he should be entitled to the prelim. And unfortunately, the court disagreed. He sought leave to the Supreme Court of Canada, who refused to allow him the opportunity to have his case heard. And this case obviously raises very important issues, because individuals who are subject to potential lengthy periods of imprisonment, in some circumstances potential indeterminate sentences as a result of certain applications made by the Crown, shouldn't they have the right, because those applications can flow from their convictions for even minor offenses depending on the circumstances of the case, to have the most procedural rights in challenging the case that the Crown has against them, to have the most opportunity to have their case heard in court, the most opportunity to test the evidence, to protect themselves the most against the greatest sentences that we can impose in our judicial system? It seems to me that that's consistent with the purpose of preliminary inquiries, even though that might not be what the criminal code says. And of course, we know that the Supreme Court of Canada can read into legislation things that aren't there if it intends for the result to be consistent with the purpose or the spirit of the law. And yet, the Supreme Court of Canada didn't even give this opportunity to Mr. Windebank, despite the fact that he was potentially facing a long period of time in jail that would otherwise have entitled him to a preliminary inquiry. This seems to be completely unfair and at odds with the entire purpose of preliminary inquiries and even the more recent limitation on preliminary inquiries that we've seen in the Canadian system. It's unfortunate that the Supreme Court of Canada didn't hear this, and that other people are going to be facing lengthy periods of incarceration for offenses that they committed historically under the Crown's dangerous or long-term offender application process. Hopefully the Supreme Court of Canada has an opportunity to chime in on the use of preliminary inquiries where people are facing those applications, rather than leaving it to whether or not they succeed at trial, and then whether or not the Crown brings the application without the opportunity to properly test all of the evidence using every procedure available to them. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.